25 minutes before 11 o'clock. John Fuller is in the studio. It is May 13th, 2015. The date is important because sometimes John can't be here. So if that's the same date on your calendar, then you're listening to a live show, and that's important because if you want to call in, if it's May 13th where you are, then you know you can call in. The number is 622-9622. John Fuller is an attorney here in Ocala at the law firm of Fuller & Fuller. The other Fuller is his beautiful wife, Janet. Good morning, John. How have you been?
Larry, we've been fine, thank you, and I hope you and everybody here and all our listeners are. It's great to be back. I have just ended up with some real scheduling issues the last 4 weeks where I've had court or depositions or something else that I could not work around, and so I have missed being here, and hopefully we have some folks listening who will have a legal question. We enjoy talking about the general principles of the law. As you know, our law firm, Fuller & Fuller, here in Ocala, handles civil litigation, business and commercial litigation, and Janet, who was a registered nurse before becoming a lawyer some 25 years ago or more, she handles exclusively Social Security disability cases in the office. So if those areas are something that you or a friend of yours or a family member have a case in, we'd be happy to talk with you. If you want to give us a call at the law firm of Fuller & Fuller, our number is 352-547-4292. And lots been going on. I think a lot of it is more apropos to the political component, which we try to stay away from to some extent on this program and focus on the law and not politics, and not get caught up in that. But it was very interesting that the legislature adjourned before its session was over. The Supreme Court of Florida, in an after-the-fact opinion, said that was unconstitutional, but essentially you can't unring the bell. You know, the dates for the session had already expired, so you can't extend those and make them come back unless the governor calls a special session, which he apparently has done. As far as another major piece of litigation that received a lot of publicity, debate, and that sort of thing was the permanent alimony bill died because the House.
Right.
It had passed the committees in the House, had passed most of the committees in the Senate, but there was one senator who adamantly refused to bring it to the floor, which they were trying to work out a compromise because that bill, and I don't know why, he put it in there, and I don't remember the senator's name, but he was adamant that this bill dealing with alimony had to have a section in it that said that it is a presumption that both parents should have equal time sharing, 50-50, with the children. That has never been the law of Florida. Florida law has always said that the governing principle of time sharing and parenting was what's in the best interest of the child. And this law went on to say that it was a presumption. Now, in the law, that doesn't mean it's absolute. It just means that there is a presumption, and in order to overcome that presumption, the other party has to put on rebuttal evidence to rebut that presumption is reasonable and good for the child. He went on and put a following sentence in the bill that he would not take out or modify, that said that the presumption could not be rebutted. Well, a non-rebuttable presumption is a mandate.
That's a mandate.
And it is completely contrary to 100 years or more, 200 years of Florida law, however long Florida's been a state. And it just shocked me because that had no business even being in a bill dealing with alimony, because the determination of the best interest of the children should never be governed by an analysis of money. Money should not determine where the children are or who has control or that sort of thing.
Right,
That's an entirely separate matter. So it's very hard to understand. I talked with the chairperson of the Family Law Division, and who was one of the authors of it. And generally, the bill said there is no permanent alimony, but we're going to recognize a sliding formula. And they put in a formula that was based upon the combined gross income of both parties and the duration of the marriage. And the shorter the marriage, the lower the percentage, and the longer the marriage, the higher the percentage. And of course, the percentages were then applied to the combined gross, not net, gross monthly income of the two parties. Well, if you had a relatively short-term marriage, this worked very well. And I thought the numbers usually fell pretty much in the same parameter.
Right.
But if it was over a 20-year marriage and one party had had achieved a high income producing status, then the pure application of the formula could end up requiring payment of alimony to the other spouse for exceedingly large sums of money. Again, in the past, alimony has always been determined by our courts and the appellate courts based upon an analysis of the needs of one party after divorce and the ability of the other party to pay alimony, as measured by an analysis of what was this family's standard of living at the time they started the divorce. If they were living in a double-wide mobile home and driving a 20-year-old pickup truck, that's one standard of living. If they're living in a 14,000 square foot mansion on 10 acres of property with a couple of barns and paddocks and that sort of thing, and they drove expensive, exotic foreign sports cars, well, that's another standard of living. And so that's what we have been used to. That has, of course, led to there not being consistent rulings where judges make the same decision, and they want to try to bring consistency to it. So it'll be interesting to see what happens next time around. It never got to vote, but if it had gotten to a vote, it probably would have passed.
And would the whole thing be called off if the spouse receiving the alimony gets married again?
Yes.
Oh, it is?
Yes. Alimony terminates upon death or remarriage. Death of either party or remarriage of the recipient party.
And if the primary money earner is going to be the one paying the alimony, that's what it sounds like, but the recipient is the one who quits the marriage.
We have a no-fault divorce in Florida,
so that doesn't matter.
The law doesn't say you have to be miserably married or forfeit your right to support if you need it and the other side can contribute to it. Now, the law now and the law in the new statute also said that the court could look at the potential income of the lesser producing party.
Okay.
Does the recipient have the capacity, the earning capacity, to go into the job market or return to a career or complete education and and achieve the ability to be gainfully employed and to become self-supporting, even if the person is not at the time of the divorce. The court can impute income to them. If someone has all kinds of skills, they've been a high-income producer in the past, they decided they just wanted to take a break and they quit working and didn't work. They were married, so they just didn't want to, they didn't have to work, they didn't want to work, so they didn't. And the court says, well, the fact that you don't have an income doesn't stop us from examining what is your income earning potential.
That makes sense.
And if you have an ability to become gainfully employed and generate an income, they will determine, you have to prove the amount, and then the court will impute that income to the recipient spouse and adjust the alimony accordingly.
And does all of that become null and void if there was a prenup that says anything separate?
Yes. If people are planning to get married and they want to address all these things, a prenuptial agreement is a little bit like having a will. If you die without a will, the laws of intestate distribution in the probate code is going to write a will for you. It's going to say, okay, you didn't have a will to tell us what you wanted.
Right.
Therefore, if you die, it goes to your surviving spouse. If you don't have a surviving spouse, it goes to your lineal descendants. If you don't have any lineal descendants, it goes to your lineal ascendants, mom, grandma, you know.
Right.
And if you don't have any lineal, either up or down, then it goes out to collateral heirs.
Brothers?
Brothers,
Okay,
sisters,
right.
Cousins, nephews. It floats on down like that under the statute. Well, what the divorce laws tell you is what happens. But if two people, before they get married, they want to resolve all matters, they can do it, except for matters concerning parenting, time sharing, and child support. The court always has
that was going to be my next question. Okay, so that's good. I'm glad to hear that.
I think we've covered that pretty much from A to Z in a summary fashion. I think that pretty well covers the basics in the financial aspects of family law. And of course, before you even get to analyzing and evaluating alimony, you look to equitable distribution. You look at what are the marital assets, what are their values, and then you divide those, usually on a 50-50 basis, unless there's some extenuating circumstances. And then you look at what is the income producing level of that, and if there's enough assets to produce income without reducing the investment or the body of the investment or selling something, but just the income stream off of that asset is enough to be self-supporting, then you're not a candidate for alimony. If you're divorcing, I know he's dead now, but for example, John D. Rockefeller, and you're going to walk away with a couple of $100 million, the income off of that's probably going to take care of you.
I would say so. John, we need to take a little break, and we'll be right back. If you have a question for John Fuller, this is a good time to call. You'll be on hold during the break, but when we come back, you'll be up next. The phone number is 622-9622. We'll be right back.
The weather is brought to you by myfwc.com. Safe boating is no accident. Clouds and some sunshine today with a thunderstorm around, mainly during the afternoon hours. The high 87 at the coast, 92 inland. Partly cloudy tonight, low 68 to 72. Tomorrow will be partly sunny, but watch out for a shower or thunderstorm in the afternoon and evening. The high 84 at the coast, 90 inland. On Friday, times of sun and clouds with a shower and thunderstorm around, mainly during the afternoon hours. The high 82 at the coast, 88 inland. From the Florida Weather Center, I'm Joe Lundberg.
They've served our country. They've kept us free. And they need your help.
We're sitting in Veterans Park. You can't sit here not realizing that you're surrounded by heroes. There are a lot of heroes in our community. A lot of heroes, unfortunately, are not in good financial shape. They're hurting both physically and financially. We step in and help directly. Our role is to reach out to them. We're there to help the veteran. We do counseling. We do outreach. Sometimes it's just coming into the office and sitting down and saying, hey, I've got a problem, and you're talking to another veteran who understands that problem.
Everybody who works for the Vets Helping Vets are awesome, and they are so kind to everybody. They're like my second family. They really are.
They have been there during the holidays. I have gotten unexpected visits, assistance.
Vets Helping Vets of Marion County needs your help. Call today, 352-433-2320, and pledge your support to Vets Helping Vets of Marion County.
It really has been a blessing.
Are you wasting hundreds or thousands of dollars on termite retreat fees? If you're not with Turner Pest Control, you probably are. Turner Pest Control offers the industry's only termite and pest control package that never charges retreat fees, ever. You can get started today for only $99. This is a value of $500 or more. This includes treatments, installation of monitoring stations, quarterly pest control, and a lifetime guarantee, all for an unbelievable low $99. Even if you have another pest control provider, visit turnerpest.com to find out how you can avoid paying those high termite retreat fees.
Loco Graphics would like to invite you to celebrate their second location grand opening this Thursday at noon. Come on by and check out their new facility, located on 200 next to Sonny's Barbecue. Free food, music, and prizes. They specialize in all types of signs, vehicle wraps, and also printing, from business cards all the way to menus and flyers. Need a logo? We've got you covered. Free business cards from 12:30 to 1:30 for new customers only. Loco Graphics for all your signs, wraps, and printing needs.
Legally Yours, brought to you by Fuller & Fuller Attorneys at Law. On the air every Wednesday morning at 10:30 a.m. with John Fuller, a board-certified civil trial lawyer for over 25 years. John welcomes your questions, from business to complex family matters to legal disputes. So tune in every Wednesday morning at 10:30 a.m. for Legally Yours with John Fuller, right here on WOCA 1370 AM and 96.3 FM, The Source.
All right, 9 minutes before 11 o'clock. Yeah, that promo, perfect timing. John Fuller is here right now. You're listening to John live if you're listening on May 13th, 2015. That's important to you because I know sometimes we have John can't be here, he's in court or whatever, so we play a rerun. But when he's live, we like to get phone calls. So let's take a couple of phone calls, John. Good morning. You're on the air with John Fuller. Thank you for calling.
Good morning, John.
Good morning. Thank you for
John,
calling. It's good to be back and talk to you.
There's a death and there are no ascendants or descendants, and the property sits there in probate for a year, and a third party pays the taxes on that property for 3 years and applies for deed. How is and there are known ascendants and descendants, but nobody moved to do anything, about it to claim the property. Is there a certain amount of time or a time limit, or how would the title to that property be cleared? Maybe taxes or sold for money or whatever. I'll hang up and listen to your comment.
That's a really good question. And I need to begin what I'm going to tell you about it with the caveat that I am not a will, estate, and probate lawyer. So I'm not at all expert in that field, and I would encourage you to talk to someone who handles that area law. But there are some great general principles there. I learned early on in a real property course in law school that there is the type of property that's known as heir property. And I was thinking it was AIR, and I'm a second-year law student. Well, it's heir, H-E-I-R, and it's where there are distant relatives of someone who is deceased who have some interest. It could be 1/50th of the estate or whatever, because as we were talking about the probate code, there are no will, there are lineal ascendants, collateral heirs, and it floats way out to what they call the third level of consanguinity. That means blood relatives out, way out. I'll leave it at that in terms of how far away from the family tree. But second cousins, first cousins, once removed, all of that. Well, that property, if no one comes forward, any heir could come forward and file a petition to probate the person who lived on it last, whoever occupied it, had title to it, did not pay taxes on it, but still owned it at the time of his or her death. They can come in as an heir at law and file a petition to probate that estate. Taxes are a lien on that property. That would be a debt of the estate. If the estate had other assets, the best way to do it would be hopefully to redeem those outstanding tax certificates before they were sold for a tax deed. Now, when you don't pay your taxes on real property, those are the ad valorem taxes, they issue they file a lien on it, and people buy these tax certificates and they bid a certain percentage on it, and whoever gets the tax certificate, they have to hold it for 2 years, pay the taxes, and if no one redeems it, which they would have to pay them for the certificate plus the interest rate that they bid it in at. Say I bought the tax certificate at a 15% rate of interest. Well, then whoever wanted to redeem it would have to do that. If you don't redeem it, then they would have a tax sale, and the person who held the certificate for the required number of years would go in and purchase that property on a tax deed. Now, that tax deed does not warrant title. So there would then have to be a probate started, a quiet title suit, which is a suit that would involve all interested parties, heirs, the tax holder who paid for the certificate, and it would then be determined, and if they could not work it out, then the property would be sold and the people reimburse their pro rata share. It can get extremely complex. It can get extremely contentious, and it's a very, very complicated area of the law that requires a lot of meticulous. You have to go to a title company and do a title search all the way back to the original patent where the property was granted by either the state or a Spanish land grant, and then come forward. And yes, there are some time frames on some of these old claims, but things like mineral rights also come up in some cases. So it's I'd suggest that you talk to a wills and estate lawyer about it. First of all, you might want to find out what the property is worth, because you're going to spend a good bit of money on legal fees and costs, I suspect, and maybe the heirs could get together and settle something within themselves and then go redeem the tax certificate before a tax deed was issued. That would be a good theoretical, but usually people have a hard time agreeing.
And I was just going to say, if they don't agree and they all have separate lawyers, that's a.
I already said, and I was partially involved in one of those maybe many years ago, and the property had been very, very. It wasn't worth anything. House on it didn't have electricity. It didn't have plumbing. Running water. When the gentleman who was quite elderly passed away, it happened to be that it was right where they were going to put in a huge exchange for the interstate.
Oh, really?
And all of a sudden, all the big trucking companies.
Was this on 326?
Yeah, all the big.
Oh, that was a national story.
We were involved in that case.
Wow.
And it was highly contested. There were 20, 30 heirs or more that came in. I think Reverend Sharpton was down here.
Is that because they knew the value of that land because of what the interstate wanted to do?
Well, yeah, the value of the land went from practically nothing to substantial because, you look at every exchange on an interstate. You see truck stops, you see gas stations, you see restaurants, you see all sorts of commercial development. And it's very
famous case in Ocala. You were the guy.
Well, no, I wasn't the guy, but I was one of them that worked on it.
Wow. Yeah, I've always wanted to, I wish I had known that in the beginning. I would have focused on that, because I've always had so many questions about that.
Well, it's been 20 years, so my memory bank
doesn't seem like 20.
Well, it was somewhere around. It was in the early 1990s, if I recall.
I remember that. I mean, I worked for a CNN affiliate at the time, and they called us to see what we knew about it. And I had to call some people and get back to them, and I don't know what I provided anymore. But
yeah, well, I'm in the same boat. I said, well, what'd you say, Larry?
don't remember.
20 years does that to you in a couple of thousand cases. But anyway, it was. All my point is that it can be very lengthy, very expensive, very complex, and very, very contentious.
John, we got about 10 seconds. How do we get a hold of you? What's your number?
Yes, our law firm is Fuller & Fuller, and our local number is 352-547-4292. Our toll-free number is 855-534-2565 or ocala-lawyer.com. on our website.
All right, and this is WOCA Ocala. Thank you, John.
Thank you.
Fox News Radio, I'm Pat O'Neill. Investigators on the scene in Philadelphia looking into what may have caused an Amtrak train to derail, leaving 6 dead, more than 200 treated at area hospitals. Robert Sumwalt of the NTSB.
We're looking at the track, the train signals, the operation of the train, the mechanical condition of the train, human performance. We are setting up a multidisciplinary investigation.
It's not the first time that area has seen a derailment.
Although the first time was several decades ago, but people still have questions about what this train derailment means and how the track may have played a role in this tragedy.
Fox Radio's Gurnell Scott in Philadelphia. Closing arguments today in the Boston Marathon bomber case. A jury will determine whether Johar Tsarnaev